Hello, Mr. Martins.
Hayi,
Hello,
minjhani?
hayi ngabo.
Ni twakala kahle?
Yeah.
Okay, a ni na problem a namanti system a yi endle yini a yi lava ku na me ni acceptiwa so but yi gine yi cinca futhi.
Oh,
I hope other members va nge vi na problem ku join.
me va sendere link.
Yeah, the same link, it's only that there was I'm sure issues at the beginning.
Okay.
From on my side is sorted, but I'm not sure if other members will have problems to join.
Okay. Kambe banda va sala vo hi brief mos.
Yeah, hi ta briefa hi ku sungula, hi ta briefa hi mo ni share ina.
Ni kombela mi ni foni
Okay.
Recording in progress.
Morning, Chairperson. Good morning, Chair.
Morning, Mr. Matonsi.
Yes, it's 10 o'clock now. We can start with the meeting. We have enough members to start. It seems as if all the other stakeholders, they are in the meeting as well.
Okay, thank you, Mr. Matonsi, and good morning to honorable members. Morning to the Parliamentary Legal Service team. Morning to the IEC commissioners and the executive, and morning to the Department of Home Affairs team in attendance. We have convened this meeting to receive a brief from the Parliamentary Legal Services and also the IEC as a result of the court judgment that was delivered on Tuesday in relation to the independent candidates' participation. So we've invited the two stakeholders to brief us on the implication of that judgment, so that the committee will able moving forward to deliberate on how we're going to engage on the outcome of the Constitutional Court judgment. Parliament has since rise on Wednesday, so we'll be guided in terms of the process we must engage moving forward. Secondly, is that we're informed that today they will introduce the Electoral Matters Amendment Bill to Parliament. I think Mr. Matonsi will brief us later on. The expectation is that we'll also deliberate on that in before we close our year next week with the joint with the select committee in a joint meeting to be briefed by the IEC and the minister so that we're able to kickstart the process for the bills that will be introduced, in particular the Electoral Matters Amendment Bill. Mr. Matonsi, I will invite you to render item number 2, and then we'll then invite the Parliamentary Legal Service and IEC, and we'll then deliberate after the 2 presentations have been made to the meeting. Mr. Matonsi?
Yes, Chairperson. From my side on the apologies, there's an apology from Ms. van der Merwe, and then also an apology that I received from the Minister and the Deputy Minister. That's all, Chair.
Thank you very much, Mr. Matonsi. Can I start with Charmaine, Parliamentary Legal Service, if there's apology, and introducing your team?
Good morning, Chair. From our side, there's no apologies. Joining me and the person who will be presenting to the committee this morning is Ms. Tilana Halistaki and also Ms. Daksha Kassan. Thank you, Chair.
Thank you very much. The chairperson of the IEC.
Good morning, Chairperson. Good morning, honorable members. Good morning, Minister and the team. We are here, Chairperson, members of the Commission, as well as the CEO and his team. Mr. Shiburi will make the presentation on our behalf. Thank you very much.
Thank you, Commissioner Miepta. The Department of Home Affairs, Director General, I have noted 2 apologies of the Minister and the Deputy Minister.
Hello, good morning, Chairperson, and good morning to honorable members, and also to the Commissioner, Chair of the IEC, CEO and Deputy CEO. From my side, it's myself and Advocate Pelelani Kumalo, who's the Chief Director responsible for legal services, and Advocate Moses Malakate that are joining. Thank you, Chair.
Thanks very much, and congratulations, Advocate Kumalo, for your new appointment. We hope that you'll strengthen the work of the department. We'll then invite Parliamentary Legal Service to give the presentation.
Good morning, Chairperson. It's Tilana Halistaki here. I'll be presenting on behalf of Parliamentary Legal Services, and because of bandwidth, I'm going to switch off my video.
You're muted and you're starting at the end.
Thank you, Chair. So as yes, I'm sure my screen is visible.
Yeah, proper. Can you proceed?
Thank you, Chairperson. As honourable members know, on the 4th of December, the Constitutional Court delivered 2 judgments on the Electoral Act, as we recently amended, this committee amended in terms of the Electoral Amendment Act 2023. These judgments were the Independent Candidate Association South Africa NPC versus the President of South Africa and others. And the second judgment was the One Movement South Africa NPC versus the President of South Africa and others. These were 2 separate applications that were heard together by the Constitutional Court on the 29th and 30th of August, respectively, and they both challenged the Electoral Act. In terms of the ICA judgment, Chairperson, the CC unanimously dismissed the application brought by the ICA. The ICA's application, they sought a declarator that item 1 of Schedule 1 is inconsistent with the Constitution. To the in the National Assembly would be filled by independent candidates and political parties. These are we know as the regional seats, and the 200 seats would then be filled by the political parties, and these would be called the compensatory seat. This we refer to as the 200-200 split. The ICA contended that Parliament acted unconstitutionally by splitting the seats in the National Assembly into 200-200, and that the split was arbitrary. It meant that the quota of votes for political parties that they had to obtain to get the compensatory seats would be much lower than the quota of votes needed for independent candidates to obtain a regional seat. And then this would infringe on equality of votes and equal opportunity. In the ICA judgment, the ICA sought the following remedy. They sought that the provision, the schedule, that amended they requested an amendment for the 200-200 split to be 350-50. And the 350 split would then be reserved as regional seats to be filled by independent candidates and political parties, and that only 50 seats would then be for political parties, the compensatory seats. They also asked for a read-in and that it be provided in the manner suggested, and that the declaration for invalidity be suspended for 36 months so that Parliament would then address the unconstitutionality of the provision. The application was, however, as you know, challenged by Parliament and the Minister of Home Affairs. So in determining the order, the CC considered two issues. Was the 200 split rationally connected to a legitimate government purpose? And did the 200 split give rise to an unjustifiable limitation of fundamental rights in the Constitution? The reasoning behind the CC's decision is as follows. Was the 200 split rationally connected to a legitimate government purpose? The Constitutional Court found that it passed the rationality test, as it achieved the governmental purpose of achieving proportional representation and avoiding the risk of overhang. While both the 200 split and the 350 split does achieve proportional representation, the Constitution expressly leaves the choice of an electoral system up to Parliament. The 200-200 split was chosen by Parliament as it passed the constitutional muster and it achieved proportionality. The 200-200 split avoids the risk of overhang, which is a crucial constitutional limit because the Constitution limits seats to the NA to only 400. In this regard, the Constitutional Court noted that the 350 split presents a foreseeable risk of overhang. The second issue was whether the 200-200 split gave rise to an unjustifiable limitation of the fundamental rights in the Constitution. And the Constitutional Court found that the ICA had not discharged the onus or established that the legislation is irrational, nor that it infringed or violated on any fundamental rights alleged by the applicant. In this light, the Constitutional Court did not find it necessary to conduct a limitation justification under Section 36 of the Constitution. Now, honorable members, this brings us now to the One Movement SA NPC judgment, the OSA judgment. In this judgment, the Constitutional Court was split on two issues raised by OSA. The majority of the Constitutional Court dismissed OSA's application for the relief regarding the recalculation method that is provided in Schedule 1A of the Electoral Act. And then the majority of the Constitutional Court declared that 31B3A 1 and 2 of the Electoral Act, which we know as the signature requirement, be declared invalid and inconsistent with the Constitution, to the extent that it unjustifiably limits the rights of freedom of association, freedom to make political choices, and freedom to stand public office. In OSA's application, OSA sought to declare the following. They wanted 31B3A 1 and 2 of the Electoral Act to be invalid. It was inconsistent with the Constitution and to the for independent candidates to register for the elections. They also sought to declare that item 5, 7, 11, 12, 23, and 24 of Schedule 1A of the Electoral Act are invalid and inconsistent with the Constitution, to the extent that these items were disproportionately favoring political parties with larger votes over parties with smaller votes and independent candidates. They also sought that the declaration of invalidity should be suspended for 24 months for Parliament to remedy the defects, and that this period included the period required for the President to assent the bill bringing such remedies. They then provided for a reading provision for both the aforesaid provisions. So OSA argued the following. They argued in terms of the recalculation provisions that the method used in the Electoral Act provided that in the event of forfeiture and vacancies, votes for independent candidates should not be disregarded, as it affected proportionality between votes cast and seats allocated, and it was advantageous to larger parties. In terms of the signature requirement, OSA argued that 31B3A1 and 2 of the Electoral Act is constitutionally invalid, as it provides that independent candidates must secure signatures of registered voters amounting to 15% of the quota of the previous election in the relevant region. This, they argue, was arbitrary. It was an arbitrary barrier of entry for independent candidates to register for the elections by placing an unreasonable high signature requirement upon them. They argued that independent candidates will have to obtain in the region of 11,000 signatures. And they questioned the purpose of this requirement, as prior to the amendment, political parties were only required to submit 1,000 signatures to contend the elections, and to satisfy the purpose that political parties are serious about entering the election race. In terms of the recalculation, the majority of the Constitutional Court held that the explanatory affidavits filed by the IC and the answering affidavits filed by the Minister and Parliament adequately showed that OSA's case had no merits and provided explanations which were not challenged by OSA. The recalculation method was fundamentally about respecting voters' choices. And there was no merit in the stance that a vote for an independent candidate is a vote that rejects party politics. The applicant's position relies on this unproven assumption. Honourable members, in terms of the signature requirement, there were 2 issues raised. The first issue was whether the signature requirement violated any rights. As a point of departure, the minority judgment penned by Zondo CJ held that the signature requirement did not violate any rights, as it did not adversely affect anyone, but it was rather beneficial to candidates in obtaining their candidature. Having canvassed already for 15% of the quota needed for the seat, they would now have to raise 85% of the quota. However, the majority judgment, which is penned by Kalapin J, held that there was a right violation, considering that the provision that regulates a right will amount to a limitation that goes beyond the regulation and limits and debtors. In other words, members, although the signature requirement regulates the right to freedom of association that is found in Section 18, freedom to make political choices, which can be found in Section 19(1) of the Constitution, and the right to stand for and hold public office, which is Section 19(3) of the Constitution. It goes beyond mere regulation, as it also deters independent candidates from even contesting an election. It does not give effect to these rights, but it rather limits the rights. It intends to exclude potential candidates from standing public office. The second issue was whether, if there was a limitation of a right, is there a justification for this limitation in terms of Section 36 of the Constitution? The Constitutional Court therefore looked at the nature of the right, and they determined that it was crucial to the functioning of the Constitution. The importance of the limitation, Kalapin felt that it was relatively low of importance for the purpose of the signature requirement, as past data showed that the absence of a signature contestation thresholds did not result in frivolous or meritless contestation. He then considered the nature and the extent of the limitation, and he argues that getting to 15% was arbitrary and has an extensive limitation, as an independent candidate will have to run 2 campaigns, one to get on the ballot paper and the second to get a seat. He then considered the relationship between the limitation and its purpose. And he concluded that there was nothing to justify or inform the approach taken by the Minister or Parliament in opting for the legislative choice of percentages based on quotas instead of a fixed signature threshold. There was no explanation as to why 15%. How is the requirement linked to the objective sought? And finally, members, he argued that there were less restrictive means, and the extent of the risk of frivolous contestation is unknown, but there are other means to prevent this, a deposit requirement and 1,000 signatures. Therefore, the Constitutional Court ordered that Section 31B3A 1 and 2 of the Electoral Act was declared invalid and inconsistent with the Constitution, to the extent that it unjustifiably limits the rights to freedom of association. The order was suspended for a 20-month period to cure so that Parliament can cure the defect. Parliament therefore has until the 3rd of December 2025 to rectify this defect in the legislation. A read-in remedy was provided with regards to Section 31B3, which the read-in is effective immediately and will continue after the 3rd of December 2025 unless Parliament amends the section. As the read-in related to independent candidates is already in effect, there is no urgency to include it in the statute book now, before the session of the 6th Parliament ends. Members, this is what the read-in provision looks like. As you can see, they struck out AA and BB, which was the percentage requirement, and they've now included totaling 1,000 signatures for each region in which the candidate tends to contest the election. That is found in that is the red underlining in the slide. And then they've done the same for provincial legislatures. What are the consequences of the constitutional order? Honourable members, the Constitutional Court's order was limited to the facts before it, and thus only dealt with independent candidates. Accordingly, the Constitutional Court did not make a similar order with regards to 27(2)(c)(b) of the Electoral Act, which, as we know, provides for a similar requirement for unrepresented political parties. This has now resulted in a situation where independent candidates are required to provide 1,000 signatures per region, but unrepresented political parties must provide 15% of the quota for each region in the preceding election. When considering the Constitutional Court judgments, when considering the finding that the legislation is invalid, we advise that the committee consults the executive and ascertain the policy position to deal with the read-in and the disparity created by the read-in in respect of unrepresented political parties. If the department is of the view that Section 27(2)(c)(b) must be amended to address the disparity between independent candidates and unrepresented political parties, then the department must advise the committee whether it would be necessary to do so prior to the 2024 elections. If it is the department's policy that the read-in or the disparity must be provided for in this legislation before the 2024 elections, it could then be included in the executive bill that has now been introduced to this committee. However, that will have an impact on the legislative process. On these process matters, our office has consulted with the committee support staff as well as the NA table staff, and we can advise the committee on how we should proceed if this is the direction that the department wishes to proceed with. But what is urgent is that if the department indicates that it is necessary for the amendment to be included in the Electoral Matters Amendment Bill, that, as I've said, is now introduced to this committee, the committee needs to know this before it does a call for comments, as this will affect how the advert to the public will be formulated, and whether the House must now whether we must approach the House for permission to extend the scope of the bill. And that concludes my presentation, honourable members. Thank you.
Thank you very much, Telana, and your team for the presentation. I'm sure there's no any other addition. The Parliamentary Legal Service will comment or respond once members have made their own comment in the IEC. Commissioner Miebza?
Thank you, Chairperson. I want to let Masiho proceed with the presentation without any waste of time, and then we can have a discussion afterwards. Thank you very much.
Thank you very much, Mr. Shibura.
Thank you, Chair, and good morning to members of the Portfolio Committee Commissioners, the Chief Electoral Officer, DG in Home Affairs, colleagues, good morning. The presentation, Chair, deals with 7 areas. However, the first area on the background, as well as the implications of the judgments, the legal implications of the judgments, have been dealt with by my colleague adequately, by Chelana adequately and competently, and on those ones we are aligned. For that reason, it would not be necessary for the Commission to further traverse those areas in detail. Suffice just to summarize the Commission's understanding of the judgment so that we create proper context to unpack the implications that the Commission sees arising from this order. And if that is acceptable, Chair, I now invite members of the committee to skip to slide number 10. As we understand it, the 200 and 200 split of the 400 seats in the National Assembly, the split is confirmed by the judgment. We confirm that there are no implications for the Commission since Schedule 1A provisions remain as they are in the Act. For these ones, there are no implications because the rationality and constitutionality of the split is confirmed. The second issue of the judgment deals with the 15% signature requirement. And we know now it has been struck down and the court has read in 1,000 signature requirement in respect of independent candidates. So it has changed Section 31B3 by removing content that required 15% signature requirement and replacing it that with the requirement that a person must submit 1,000 signatures in order to stand for election. We will deal with the implications in the slide that follow. Perhaps the biggest risk arising out of the court's judgment is bullet 3, in that while a remedy is provided in respect of independent candidates, and that is after the court having found that the requirement or the quantum of signatures as a result of the 15% requirement is too high and irrational. The court nonetheless still expects unrepresented political parties to meet that requirement. And that we think is a big challenge because it creates uncertainty, but also it creates perceptions that different categories of contestants are treated differently by the same piece of legislation. I now move to slide 11. In this slide, we unpack the implications on candidate or for candidates and for candidate nomination. The first one is that an independent candidate who wants to stand for a seat in the National Assembly must submit 1,000 signatures to demonstrate that their contestation is not frivolous. It is a numerical 1,000, irrespective of the size of the constituency. For example, Gauteng, with its 16 million population, a candidate who wants to contest there must receive 1,000 signatures, in the same way that a candidate who wishes to contest in the Northern Cape with a voter population of 600,000 must also get 1,000 signatures. So that is the first implication. The second implication is that signatures, because these are elections for the National Assembly, for a seat in the National Assembly, the signatures are not confined to a region. So a person may be nominated by 1,000 candidates from across the country. The requirement being that the people who support the candidature must be registered on the national segment of the voters' roll. We say this because in the Colapen judgment, the reading text provides that the names of voters must appear on the national segment of the voters' roll. The third implication that an independent candidate may not be nominated to contest more than one region with only 1,000 signatures. In other words, the 1,000 signature is a requirement for each region in which a candidate stands. So you can't say, I have 1,000 signatures and therefore I can use that same 1,000 signatures to support my candidature in multiple regions. This is so because the provision that a candidate must obtain 1,000 signatures for each region in which the candidate intends to contest an election, and each is a determinant that refers to individual regions. The requirement of 1,000 signatures mentioned in the provision applies to the regions individually. It applies for each region the candidate wishes to contest. So if a candidate wishes to contest 4 regions, they must submit 4,000 signatures of voters registered on the national segment of the voters' roll. The takeaways here are 2 things. 1, there must be 1,000 signatures for each region. 2, the 1,000 signatures do not have to be of voters that are registered only in that region. It could be any voter who is registered on the national segment of the voters' roll, because the contestation is for a seat in the National Assembly. The third implication, which is now obvious, is that unrepresented party, an unrepresented party, a party that exists but still does not have a seat in a municipal, does not have a seat in a provincial legislature or National Assembly. That party may have seats in a municipal council, but the test is that unrepresented means it does not have representation in the sphere of the election that is being contested, which is national and provincial. So that party must still meet the 15% requirement of signatures in order to contest an election. This is over and above the 1,000 signature that the court in the Kwalapen judgment referred to. The 1,000 signature has nothing to do with contestation. So you are asking then a party to meet 2 requirements when it is not acceptable for independents to meet 2 requirements, because a party must first get 1,000 signatures in order to register as a party. But above that, in terms of the judgment, it must still meet 15% of voters in each region in which it wishes to contest before its name appears on the ballot paper. We wish now to make a few concluding remarks, Chair, on behalf of the Commission. The first one is that because the court has amended the law by removing the requirement for 15% as a requirement to contest and replaced it with 1,000 signatures, we are now in the process of rewriting our system, because our system was developed on the basis as a law stood, i.e. 15% of votes linked to a quota in a region. We are rewriting that system to accord to the judgment of the court as it relates to independent candidates, to make it clear that independent candidates must submit 1,000 signatures in each region they wish to stand for. We will indicate shortly when the system rewrite will be completed. So that the first point, and the second point relates to that point of rewriting the system to remove a 15% signature requirement to a 1% signature requirement. And because the relief does not extend to political parties, it has a way, it impacts on the architecture of our system, because our system was built on the premise that there is a single requirement for both represented, unrepresented parties and independent candidates. Now there are 2 distinct requirements. We must extend the design of our system to include a certain category that had not been provided for in the law, and therefore could not have been anticipated and provided to in the system. We are, however, moving with purposeful alacrity so that we make sure that we do not delay the independence and unrepresented parties more than we have done up to so far. We are also reviewing candidate nomination regulations so that they are consistent with the determination of the court. The regulations were drafted on the basis of the Act as it stood, as it had been brought into force. Given the court judgment, it is necessary to review those in order to bring them into line with the Constitutional Court judgment. The fourth remark, Chair, is that additionally, we are adapting our educational material, online content, and animations in order that they are consistent with the order of the court, because we have developed material, voter education material, civic education material, on the basis that people who wanted to contest must meet 15% requirement for signatures. We are changing that to indicate that for independents, those persons must meet 1,000 signatures, while for parties, the requirement still stands. Predictably, because, let me take it a step back. One of the reasons of introducing a signature requirement was that with each election, the number of contestants increase. However, it does not result in plurality of voice in the National Assembly or in provincial legislatures. What do we mean by that? That since 1994, you've moved from about 14, 17 parties to 48 parties, unique parties in 2019 contesting an election. And all those additional parties have not had enough votes to enjoy representation in the legislative assemblies. Even though in the South African context, there is no electoral threshold. In other words, there is no requirement that the party must first meet a certain percentage of votes before it is considered for inclusion in the seat allocation process. And we do not raise this point, Chair, because we have a desire to keep out contestants, or we want to limit the multiplicity of voice in the political space. We raise it, however, principally from the point of view of a voter. If you accept that in an election environment, the only tool available to a voter to identify a party or candidate of their choice in an election, who record their vote for that party or candidate, is only a ballot paper. And if you present a voter with an unwieldy ballot paper that is on multiple pages in more than one column, you are impacting on the ability of that voter to exercise a choice that is informed. Because people may feel pressured and miscast their ballot. By miscast, we mean they make a mark, a legitimate mark, but they do not intend to make a mark against that party. It could result in spoiled ballots, which could be that a person votes in one column and also votes in another column, or votes on the first page of the booklet and also casts a vote or makes a mark on the second page of the booklet. That would result in that ballot paper being regarded as spoiled. So the only protection that the requirement, 15% signature requirement, intended to do was to ensure that from an election management perspective, we can still present a voter with a ballot paper that they can use, that is intuitive, that makes recordal of their choice very clear, so that we can record that choice as made and translate that into representation in the various legislative assemblies. It is an obvious consequence that the cost of administering elections will increase with the relative increase in the number of contestants. The more the voters, the more paper you need, the more the contestants, the more paper you need to generate a ballot paper. And as we had said in the past, we are now in the realm of a ballot paper that is beyond one column. Now we are seriously in the realm of a ballot paper that is at least 2 columns and more than 1 page. So we are looking at we are in the realm of a ballot booklet and no longer a ballot paper, because anyone who can get 1,000 signatures and raise a deposit will appear on the ballot paper. The 6th point that we're making is that likewise, the increase in the number of contestants will have corresponding impact on increased cost for additional ballot boxes. The size of the ballot boxes are going to be very lengthy. If they are booklet, it means the ballot boxes will fill up quickly, and therefore we need to replenish the ballot boxes. We are going to need additional staff to help us deal with the increased volumes and complexities at voting stations. And those are going to increase the volumes of our logistics and the unique costs for those logistics. Last point to be made on the previous slide is that hitherto, the Commission has always released results within 3 days from the date of an election, even after considering objections that are material to the outcome of that election. We are no longer able to guarantee that will be the case, because if you have long ballot papers, if you have ballot papers set on more than 1 column, if you have ballot paper that spans a number of pages, it's going to take longer to vote, it's going to take longer to count, it's going to take longer to translate those marked ballots into results. So we are contemplating looking at a result announcement that is beyond the 3 days, but will still work within the legally required 7 days to release the result. The second last point that we're making, Chair, are that the design element of the ballot paper used hitherto will change, and I think we've made that point. I do not need to repeat those points. They are well set out on slide number 16. On the last slide, Chair, when the Commission was presenting was finalizing the presentation, there were at least 2 applicants who had indicated that they are going to approach the Constitutional Court to challenge the requirements for unrepresented political parties to still meet the requirements in Section 27 of the Act as it stands. As we said, this increases uncertainty in the environment. This will also delay, because if the court finds in favor of those applicants, if they eventually go to court, it would mean we must then come back and review some of our systems to change them again, because we can only build system, or we can only pass regulation on the basis of the electoral law as it stands. We cannot amend or vary the law in anticipation. That concludes the input of the Electoral Commission, Chair. With your permission, I wish to yield to the CEO and/or Chairperson of the Electoral Commission if there are issues that were not well articulated. Thank you.
Thank you very much, Mr. Shiburi. The CEO, but I thought that he has best represented the collective. But if there are other issues you think may not have been clearly articulated, you are invited to comment. CEO?
Thanks, Chairperson, and greetings to members of the committee. I think the last point that my colleague, Mr. Shiburi, dealt with requires that we underscore it. And that is the nature of the collar pen order has now led to a situation where there is imminent consequent litigation. In fact, to be precise, Rivonia Cycle, as well as BOSA, Build One SA Movement, Build One SA Party, have placed us on terms to say that by the end of today, we need to confirm that we can do a write-in similar to Section 31 as it regards to independent candidates. Of course, the Commission is unable to give such a guarantee. It can't do. The Commission is not a lawmaking institution. It can't, through administrative decision, supplant the law and do a write-in. It's what they're asking us. It's way outside of the statutory remit of the Commission. So we will be responding accordingly. But it is eminent that there's going to be a subsequent litigation insofar as Section 27 goes in respect of the signature requirements for unrepresented parties. So we are in a very fluid and fraught environment at the moment. I just wanted to underscore that point that Shiburi made.
Thank you very much, CEO. Commissioners, Chairperson, if there's any matter to raise before members comment.
Chairperson, I'm covered. I have my colleagues, and if there's anyone that thinks that we're not covered, I'd like to invite them to briefly deal with. I yield to them. Commissioners?
Commissioner Masuku?
I'm covered, Chair. Thank you very much.
Commissioner Pile?
Thank you very much. I'm covered. I only wish to emphasize the costs of the escalating costs and time that would be taken by litigation that is already before us, but others that may yet to come. Thank you.
Thank you, Commissioner Mashinini. Commissioner Love?
Yeah, Commissioner Mashinini is struggling. He called me.
Okay.
Good morning, Chairperson. Good morning, honorable members. I'm covered. Thank you very much.
Okay, thank you. Commissioner Mashinini, let me come back to you.
Chairperson, okay. He's struggling, Commissioner Mashinini, so let's pass.
Okay, well, thank you, Chair. Members, these are the two presentations that have been raised to the committee. The DG, the issues that the Parliamentary Legal Services have referred to the Ministry and the Council to come back to the committee. Do you think there's a comment you want to take before members engage on the two presentations? I know that you are not requested to prepare a presentation, or the minister. Is there any other matter you may need to take, given the last matter raised by the Parliamentary Legal Service? DJ?
Well, thank you so much, Chairperson and honorable members, Chairperson of the IEC and the Deputy CEO and the CEO and the colleagues from the Parliamentary Legal Services. I think, Chairperson, safe to say that we've taken note of what Talina has recommended and the presentation by the IEC. We have been requested to come and present to the Portfolio Committee and the Select Committee on Security and Justice on the Electoral Matters Amendment Bill, and we'll use that opportunity to respond to some of those issues. Thank you so much, Chairperson.
Well, thanks very much, DG. Members, I'm going to invite for your comments on the issues that are raised by the Legal Service, Parliamentary Legal Service, and the IEC. In particular, the caution that the IEC raised to the committee in their last two lines of the presentations. I'll invite Honorable Lukota, Honorable Bongani Bongo, Honorable Ross, Honorable Mukhale, Honorable Molekwa, Honorable Kanyile, Honorable Techana, Honorable Pillay, Honorable Ramolobeng, and Honorable Mudisemtia. Veteran Lukota, in that order. Okay, Honorable Bongani Bongo.
Thank you very much, Chair, Honorable Chaban. I would like to thank the presenters. I think the presentations are well prepared, and also thank the Constitutional Court itself with this important judgment in the history of this coming election. I think the judgment also was very much in order. We will not generally second guess what the court said in terms of minority and majority, but all we can say is that we know the judgment. And my observation is that the IEC is well prepared for the elections from where I'm sitting, because even the way in which they interpret the judgment itself. What I would want us to do, and what I want us to request in this remaining period, even before we may have to request Parliament to grant us a permission to accede to the advice from legal, that we may have to bring the executive so that we can also check the state of preparedness and their also interpretation of what they are expected to do. I think that is what we must, without delay, deal with. But we note all the presentations from legal and from the IEC. I'm quite very happy that I think we were on the same page on exactly what must happen. Thank you very much, Chair.
Thank you, Advocate Bongani Bongo. Honorable Ross.
Thank you, Chair, and thank you for the presentations. Chairperson, once again, I would just like to plead. These are the first times that I have seen these presentations. And I asked about whether this meeting was going ahead. I asked them this morning, where is the link to the meeting? And then was informed that there were documents to be read. It makes it extremely difficult to perform parliamentary oversight when you don't have the documents, when you're seeing them in the meeting. And I'm pleading with you, Chair, that this please needs to be corrected. That for some reason, we always get an email with the agenda, with everything, with the attached documents, and then we consider it in the meeting. And now we're asking for links and all of that just before the meeting, Chair. So please, this is a very important matter to be addressed. But Chair, I'm happy that this disparity was picked up and mentioned. Just a few technical questions for the legal services, I suppose. The 1,000 in each region, it's mentioned that these are from voters on the national roll. Can the same persons then sign for each region? If these are now from people that are from the national roll. So could somebody say, I'm standing in 4 different regions, but I get the same 1,000 signatures for each of the 4 different regions? If we could just get some clarity or your views on that. Then the reading judgment, it talks about submitting these signatures in the prescribed form. I would just like to understand, what is that prescribed form? Because I remember that we had this discussion during the deliberations that there's going to be a burden on the IEC to verify these. So if you have to get, let's say the example that you give of somebody standing in 4 different regions, an independent candidate, so that's 4,000 signatures there, and you have even just 10 candidates, then you have 40,000 records that the IEC needs to go through and verify that they are indeed on the voters' roll. So I'd just like to get an understanding of what is that prescribed form. because we as the committee, we agreed that there shouldn't be an unnecessary burden on the IEC to try and verify these documents from written submissions or faxed copies, etc. Then another question for the legal services is, the amount of 1,000 was read in as an interim measure. Now, does this set an upper limit? How does I suppose the next parliament that looks at this deal with this? Because we as a committee we looked at various numbers, and actually we ended, I think, on the lowest number that the IEC provided us, based on their considered opinion. We agreed that we would go for, I think, the lowest of the various options that were available. So does this 1,000 now set some sort of an upper limit? And how does Parliament address this going forward? Then, Chairperson, we have the bill, the matters bill that's being tabled today. And my understanding is that if we now try and bring in something that hasn't been requested yet, for example, bringing in the electoral reform on the signature requirement now, that this is going to bring in new elements of complication to the schedule that we saw last week, if I'm not mistaken. And that schedule, it said that if we are absolutely diligent and we process these consequential amendments concurrently with the NCOP, that we can reach a date of the 28th of February to have the bill go through Parliament, bearing in mind that thereafter it still needs to go to the President to be assented, and then you need to do the regulations on that. Chairperson, my view is that we don't have any time left to extend scope on the amendment bill that is coming through Parliament now. Because as it is with such tight deadlines, we're sitting at the 28th of February. So our next registration weekend is the first weekend of February. Then that indicates an election date of May. So if you try and in any way introduce any element that extends this deadline, then you're talking about the middle of March or potentially worse. And then the regulations still need to be amended and finalized. And then the electoral timetable can start. So I don't know if anybody can correct me if I'm wrong here. But to my mind, we just can't afford to bring something in like this that hasn't even been requested. So there is a read-in judgment for the persons that felt aggrieved. The unrepresented parties did not contest it. They did not join the matter of the independent candidates. And it indicates that they're happy with the 15% chairperson. So we as a committee, we've received heavy criticism for delaying. And 99% of the time, it just hasn't been our fault. We've been waiting for something for the executive, etc. So we agreed that 15% was reasonable. The court heard the concerns of the relevant stakeholders that believed it was unfair, and they provided a read-in judgment that we can go ahead with. So we have no time, Chairperson. And then my final point, Chair, is just more of an administrative one. There was also a Constitutional Court judgment on arraignment and Anderson matters in the last week. And I'd just like to request that for the next Parliament, that these Constitutional Court judgments, etc., that they get added to a list so that the next Parliament doesn't have to find them. I know it's in our legacy report that those outstanding judgments must be processed within 24 months. But I'd just like to request, Chair, if we can also just, our researchers and our support team can maintain a list of these matters so that that the next Parliament can process them in a sufficient amount of time. Thank you, Chair.
No, thanks very much, Honourable Ross. I think let's pack the issues of the legacy report, because I think you know that we are currently dealing with the legacy report. The point that we're raising, a fine expression on that discussions with the committee, but noting the issues that you're raising in relation to the two presentations. Thanks very much, Honourable Ross. Honourable Mkhale.
Thank you very much, Chair. We welcome the presentations by the IEC and the legal team. Our input, Chairperson, on this presentation based on the court judgment by the Constitutional Court is that while we accept that the court has made a ruling with regards to the 1,000 signatures for independent candidates, we request clarity, like Honorable Roses earlier on said, if this 1,000 will be same people for all the different regions, or which makes it just a list of 1,000 names for all the regions. So it will be new signatures altogether. So clarity in that regard will be appreciated. However, we request that this, because now it has lowered the threshold from what we had initially set as the committee, there must be a very stringent verification method, Chairperson, because if you lower the threshold to 1,000 signatures, anyone can just go and get those 1,000 signatures. And it creates the problem that we're trying to address by introducing these measures, put these measures in place of ensuring that we don't have a bloated ballot paper, which is likely going to be the case. Yeah, we're likely going to find ourselves with a booklet, which is unfair for the voter. So we will request that the verification of these 1,000 signatures must be very stringent, and those who are found to have submitted people who did not consent to provide their details to support those particular candidates, they must be disqualified from participating in the upcoming election. So it must be like that, Chairperson. Otherwise, we're really going to find ourselves with hundreds and thousands of people throwing their head wanting to contest because they feel they can just easily get those 1,000 signatures and submit to the IEC. So we are calling for a very rigorous process of verification to ensure that we weed out all those unnecessary chance takers. The issue of the unrepresented political parties, if they want to take the matter to court, we can't stop them, Chairperson. Let them go ahead. But we think that threshold must remain, that 15% requirement should remain for political parties. We'll see what happens if they take it to court. Thank you very much.
Thank you very much, Honorable Mukhale. Honorable Mulekwa.
Thank you very much, Chairperson. I would also appreciate all the presentation as presented today, and also commend the IEC Chairperson on the work they have done after learning about the Constitutional Court judgment. I also think, Chairperson, that because of the implication of the judgment, the IEC will have to continue with a program of voter education program so that the people must be able to be aware of the court judgment and also be prepared on the voters' day on what should be expected because of the implication that are there. And Chairperson, I think the judgment bill has also have implications on the finances of the IEC because of other work that need to be done by the IEC, which means the department will have to chip in and employ other means to assist the IEC in order to make sure that the IEC meet the target. The other issue, Chairperson, is that I just want to check if, because of the due to the judgment, I think the IEC also indicated that the number of contestants will increase and also the size of the ballot paper will also have to be reviewed. So I just want to check on the issue of the time on the voters day, because the stations are opening from 7 o'clock to 9 o'clock. Whether the time will be reviewed or there are any other mechanism that will be employed, because the IEC also indicated that, which means one person will take long because of the longer of the ballot papers. So which means this will also have implication of the time on the voters day. So I just want to check what is going to happen. The time will be reviewed, or whether there are any other mechanism to assist in making sure that there are no any hazards on the voters day. But otherwise, Chairperson, I want to agree with other members on the issue that they have raised. Thank you very much.
Thank you very much, Honorable Malekwa. Honorable Kanyile.
Thank you, Chairperson. Good morning to you and to everyone in the meeting. Chairperson, I note the presentations as well, together with the court judgment. I have been largely covered by Honorable Rose. However, I only have one question to IEC. If they perhaps have an indication right now of how many new political parties have registered or independent candidates, and when will be the closing date for them to accept new registrations of people that are going to participate or contest the elections. Thank you very much.
Thank you very much, Honorable Kanyile. Honorable Kwase.
Thank you very
much. Proceed.
Thank you very much, Chair, and good morning to all the colleagues on the platform. Chair, I'm largely covered by my colleagues that spoke before me, but maybe one last question. I want to check, with this collection of the 1,000 signatures, is it a process that the IEC will be overseeing to make sure that the proper collection of signatures have been done, Chair? Because as Didimalo, I think I don't know if maybe the forms one would like to know if that process will be administered by IEC to avoid a lot of things that may come up. To say Didimalo said where she said she just sat down and had a signature campaign of individuals. I just want to know about the administering of this collection of signatures of individuals who want to stand as independent, Chair. I think also I'm covered by Honorable Kanyile. My interest was, Chair, to know when the process of registration for contestation will start and when it will end. Thank you very much, Chair.
Thank you very much, Honorable Kwase. Honorable Tejana.
No, thanks, Chair. Let's just acknowledge what the presentations, the two presentations. I'm covered by Honorable Mukhale with respect to the role that the IEC must play in the collection of those 1,000 signatures, because we all know that there are other ways in which you can do that collection. It can be open up to manipulation. There's a court judgment that says, yes, we must have 1,000 signatures, but to make sure that there's stringent ways, IEC has to play a solid role in that respect. And then we remain with the 15% because no one has complained that there's a problem of in the other parties of that issue of 15%. So it remains. There's no reason for us to even be debating it. We just need to leave it as it is. Otherwise, the rest of the issues I'm covered, Chair.
Thank you very much. Thank you very much, Honorable Tijana. Honorable Pillay.
Thank you very much, Honorable Chairperson. Chair, firstly, let me express my gratitude to all honorable members and DG and everyone who has passed their messages of condolences. As a family, we take strength from your messages and support. Chair, I want to raise very strongly the administration of our committee. And in line with what Honorable Ruas has already mentioned, Chair, it's more than one occasion that we have had serious challenges. And I think that you would have to correct this moving forward. It cannot be, Chair, that we are going to continually having these challenges of administration. I mean, there are so many outstanding things that we could have done as a committee. Oversights. Let me take an example of the study tour in direct relation to this process of where we're going to have a lengthy ballot. We could have went and investigated and looked at electronic voting systems, come back, and it would have helped the process of this long ballot. But indeed, we were not able to do this. And I think it is most disappointing that we have to continually raise concerns of administration, Chair. And I really want to plead with you as the chair of this committee to please indulge the Secretariat and to correct this moving forward. Chairperson, in relation to the two presentations, I note it and welcome it. I must also say that while I respect the Concord and accept their decisions, it is rather disappointing that after a lengthy process of deliberations and public hearings and public consultation, it has been overlooked in respect of signatures. But be that as it may, it's water under the bridge that we have to accept and we have to be able to move forward. I know that we are going to deliberate at a later stage, but I think one of the things we have to consider is indeed the signatures of political parties in respect of independent candidates. A question that I have is in relation to what Honorable Molekwa may have raised in terms of now that the IEC is saying that the ballot will be longer, it's going to take a longer period of time to go through it and cast your vote. Are we going to be able to conduct elections on one day? Or is the IEC looking at the possibility of having an election over 2 days? I think it's an important question that we might have to ask. And only given when we are aware of what the number of candidates that are contesting the elections are going to be. The second one is administratively, it's going to be a nightmare. How would we determine if an individual supports an independent candidate in one region and a different independent candidate in another region, or perhaps even support or put their signature, fix their signature on more than one person? What legal ramifications will that have if a person is seen on more than one of those signature lists? I think that it's important for us to go through this, deliberate, so that when we come back, we look at other mechanisms of how we can be able to fine-tune a more stringent process so that we are able to deal with what we have now. Thank you.
Thank you very much, Honorable Pillay. Honorable Ramolobe.
Good morning, Chair, and good morning to all colleagues on the platform. Chair, let's note the presentation. I think my colleagues already have reiterated points that I wanted to speak on. The readiness of the IEC by Honorable Bongo, including also the stressing on the signature verification process. I think it would be quite important that IEC gets to take us through what measures are they going to put in place so that we do not have any unquestionable signatures coming to play. And the last part would have been what Honorable Molekwa, which was further reiterated by Honorable Pillay, on the longer ballot matter. It's something that we must not ignore. Maybe after the the closing date of registration of independent candidates would have an idea of what the ballot looks like, but it's something that should be considered, that perhaps extensions of time normally would open voting polls 7 to 9. Are we looking at extending time for polls, or a consideration of 2 days, seeing that the ballot is long? And if it is long, it's going to take time for each person to go in and cast their vote. It might be easy to us who politically would know what is it that we're going to vote for, but for an ordinary citizen that would want to go and cast their vote, it might be difficult, especially in locating the party or an independent candidate they would want to vote for. So I think that should be made a consideration, Chair. Thanks.
Thank you, Honorable Ramolobeng. Honorable Modise Mtia. Okay. I think thanks very much, honorable members, for commenting on the two presentations. Parliamentary Legal Service and the IEC, the understanding of the inputs that are presented are intended to seek clarity so that members at the time we're going to deliberate and formulate a position on certain areas you are raising, we are more clearer, particularly on the issues that you are raising. I think that stand out, which the IEC you are raising, Honorable Commissioner Pillay, is on the issue of cost implications that comes with this outcome of the judgment and moving forward. And there's a side which has been raised by Mr. Shiburi, that the CEO Kolobe, that there are other parties that will continue to contest the issue of the signatures in relation to the percentage. That will mean any other outcome that will follow, it will also redirect the administration work of the IEC in terms of preparation for 2024 elections. We also note that we will receive a briefing from the DHA on this matter, but in relation to the electoral amendment bill. So I think your briefing assists us to able to formulate understanding as we will then come back for the deliberation to take a position as we move forward on these key areas that are raising. And all members have raised critical areas that will assist us to move forward. Your response may assist, and I think are waiting for the Minister and his council on the issues that the Parliamentary Legal Service has requested them to, and the DG has confirmed that they will be able to take advantage of the Tuesday meeting to interact with us during the joint meeting. I think the ballot matter, which the committee that in the period in which elections are going to be conducted, or the time frame that normally we conduct elections is going to be exceeding as stipulated. It's an important area that you are also raising. I think in the final analysis that if given the challenges and the short periods that we'll be engaging on, we know that the IEC can stand for, or has been demonstrating over time, whether we can demonstrate for fair process, both on the registration and also on the outcome of the elections. I want to invite the Parliamentary Legal Service to respond on the comments of the members and also the IEC to respond on those comments, and then we'll outline a process forward. Parliamentary Legal Service.
Thank you, Chairperson. Chairperson, a lot of the questions were related to implementation of the Electoral Act, and Parliamentary Legal Services aren't the implementers. But with regard to Honourable Roos's question regarding the 1,000 signatures, unfortunately, this is an interpretation issue. And, usually we would say, what is the intention of the legislature? But in this case, it is a read-in provision provided by the Constitutional Court. So, with regard to the interpretation, we cannot give an opinion. I think it's best left up to the implementers, the IEC, to give a purposeful interpretation to that read-in and what works best for them, what they've interpreted it as. And with regards to the upper limit, I think it is safe to say that it is 1,000 signatures, that there would be no need for 1,001, but the bare minimum would be 1,000.
Thank you, Telena. Are you done, Telena?
Yes, I am done.
Okay. Any comment from the Parliamentary Legal Services?
No other comment. Thank you, Chair.
Nothing
Okay.
further from me, Chair. Thank you.
Okay. Thanks very much, Commissioner Miebza. I'm not sure if you want us to invite Mr. Shiburi or the CEO, but I think you'll assist us proper on the team that must start.
Chairperson, thank you very much. I will refer the matters to the CEO, and if there's anything he wants to refer to his team, he can do so. I just want to make 3 comments very briefly. I note the issue in relation to the consequential amendments raised by Honourable Roos, and I think there is a warning that he's giving that's worth seriously looking into. We just need to understand the terrain in which we are now operating. His concern is that the timeframes are very aggressive, and yet they will land us way into the future, beyond timeframes that we may be anticipating. That, I think, it's a matter, if I understand, I hear him say. On the second comment, I've heard members raise the concern with respect to the verification of 1,000 signatures. I understand the concern. I want to ask honourable members to be very careful, not to let us legislate through regulations. We will not be in a position, and this is where the danger is. We have been here before, where regulations have been challenged because they've gone way beyond what the legislation say. The question of ensuring that 1,000 signatures are valid, it's a matter of careful consideration. And the statute, as it stands at the moment, perhaps is not dealing with what members may necessarily be contemplating. So I'm saying we will look at this matter, but I'm fairly careful, and I want to issue the warning that it cannot be that we will then be legislating through any regulation that may come in this respect. The third issue that I want to raise is that I'd like to appreciate that members are, like us, are worried about what this judgments mean for the ballot paper, the candidature, and all these other things, even taking into account that we do not disenfranchise candidates that otherwise would have won an election, and so on and so forth. But I want to say that taking all of this into consideration, the Commission will retreat and look at the complexity of the work that is before us. There are certain things we are empowered to do in law, like extending voting hours and so on and so forth. But there are others that we may not be able to do. The Commission, once it has looked at these matters, will be able to advise on the issues. Voting day in the Electoral Act, you will recall, is not defined it is defined in the Local Government Municipal Electoral Act, precisely for the reasons for some of the reasons that have been advanced today. And voting day is one day. It's not, a number of days. And that would be an issue we may need to consider when we deal with matters of complexity in this election. When we know how many candidates are going to be contesting, we now know the final form of the ballot, and we will need to deal with other issues. I just thought I limit my comments to those three issues for the moment and invite the CEO to deal with the questions that have been raised by honorable members. CEO, up to here's your presentation. Sorry, kindly respond to the questions, and Chair, thanks for the brief input the opportunity to give you the brief input. Thank you very much.
Chair, through you, Chairperson of the Portfolio Committee, Ndate Shiburu will deal with the questions, then I'll sweep if necessary.
Thank you. In that order, administration.
Thanks, Chair. I'll respond in a thematic way. There's at least 4 broad themes that arise from the input by the honorable members. The first implicates the 1,000 signature requirement, and there's at least 2 issues that arise from there. And the first one is whether a candidate can be nominated using one set of 1,000 signatures across more than one region. The answer is no, because if you read in the order of the call-up and the majority judgment, it requires that a candidature must be supported by a signature, 1,000 signature for each of the regions. So how we are revising our system is to check for duplicates in ID numbers. If a person, so that we avoid a situation where a person harvests only 1,000 signatures nationally, and they use those to contest 9 regions. So our understanding of the intention of the read-in clause is that a candidate to be valid must be supported by at least 1,000 signatures for each of the regions that they are contesting. And to say each can coexist with one set of 1,000 signatures, I think will be stretching the interpretation of that reading clause beyond what it was intended. The second issue related to signatures is the administration aspect of it. One, to ensure that those signatures are properly harvested, they belong to the voters who support the candidate. The Commission is not intending to assume the administrative responsibility for the signature harvest. A candidate has the obligation, in a form that will be prescribed in the regulation, to collect signatures, including the details of owners of those signatures. We have built a portal that we are now updating to align to the order of the court, and a candidate or a party will then, independently of the Electoral Commission, capture the ID numbers of the people who support their nomination, and they retain on file the signatures of the voters who support their candidature. On short notice, the Commission can call for those signatures so that it checks if there's anything untoward. But there is no intention that people submit signatures to the Electoral Commission when they submit their candidate nomination. The system is built as follows in brief terms. A party creates a profile, we give them authorization, or a candidate. They capture the ID numbers of the people who support their nomination. That of 1,000 people that you've captured, X are registered as voters, X are duplicates, and therefore can't support you in this region because they've already been accounted for in another region. That's how the system will work. And the Commission may do a spot check and ask for hard copies of signatures for for verification, but the responsibility to keep the hard copy signatures rest with the candidate or a political party.
Sorry, Mr. Honorable Kanyile. Thank you. We can proceed, Mr. Shibor. Sorry for that.
Thank you, Chair. The second category or theme relates to the review of voting hours or days, and that the commission, the chairperson of the commission has already dealt with. I will not repeat. The third category related to party registration and cut-off for application for registration of political parties. And also there was a subsidiary question of the number of parties that are currently registered. The commission is the registrar of political parties. And there is a distinction that I think must be repeated here. An entity that wishes to register and therefore exist as a party and enjoy protection as a party has to meet the scheme in the Electoral Commission Act. That scheme is that it must submit a constitution, it must publish its identifiers, and those identifiers must not be too similar to the identifiers of a registered party to an extent that it may cause confusion. That party must submit also a deed of foundation indicating that at least 1,000 persons support the formation of a party. That is at the national registration. Existence of a party affords a party certain protections, but it is not an automatic, doesn't mean that once you are registered, automatically your name will appear on the ballot paper. For that to happen, a party must still meet the requirements for contesting. And those requirements will be set out in the election timetable as soon as the election date is made known. So on the cutoff date, there's no opening for candidate nomination, there is a closure date for candidate nomination. On that date, at 1700 hours in the afternoon, a party must have submitted their list of candidates, they must have paid a deposit, and they must have confirmed that any of their candidates are not prohibited from standing for election in terms of the Constitution. If they meet those requirements, that party's name will then appear on the ballot paper. For information, there are over 578 unique parties registered in the Republic. 360 of those, give or take, are registered to contest the national and provincial election. But it does not follow that 300 or at least 360 parties will appear on the ballot. They must first meet the requirement to contest that, as I said, was a submission of a list, a payment of a deposit, and confirmation that candidates on their list are not barred from standing for office. The scheme for independence is different. An independent does not have to register or apply upfront like a party has. All that an independent needs to do is to meet the requirement on the date of close of candidate nomination. And those are payment of a deposit, confirmation that they've submitted 1,000 signatures for a region in which they wish to contest, and confirmation that they are not disqualified for standing from office in terms of the Constitution. And if they meet those requirements, a candidate will appear on the ballot. The last point related to the 1,000 signatures is that the last point on the registration of parties, the guide that we can offer is that because party registration is continuous, there is no cut-off time on which we say we no longer accept applications for the formation of parties. But the broad guideline would be a party must have been registered on the date of close of candidate nomination. And if it submits those documents before 1700 hours, it would have met the requirement to stand in that election. The last point to be made on the signatures of supporters, there is no bar in the law as it stands or any requirement that restricts a voter to nominate or support only a single party or single candidate. So it is possible that Masego Shiburu could nominate Party X and still support for independent candidate Y. Thank you very much, Chairperson.
Chair, thank you very much. The floor is clean. There's nothing to sweep. Thank you.
Thank you, Mr. Commissioner Miebza. If the commissioners want to add.
Chairperson, thank you. I'm going to check on them. I must make a correction. The Electoral Act has also been amended to define voting day. I used an old copy. Please accept my apologies. So election day or voting day is one day in the Act at the moment, but these are matters that are indicated we can look at as the Commission and indicate how we move forward. Can I check with my colleagues if there's anything that you want to add?
Let me assist you, Commissioner Love.
Thank you.
Thanks, Chairperson. There's nothing from my side to add. I think the DCO has covered all the bases. Thank you.
Thank you, Commissioner Masuku.
Thank you very much, Chair. I am covered. I think the matters have been dealt with adequately. Thank you very much.
Thank you, Commissioner Masuku. Commissioner Pile.
I'm good, thanks, Chair.
Thank you, Commissioner Mashinini. Earlier on at difficulties of the network.
He's still not here, Chair. I have spoken to him.
Okay. Okay, Commissioner Miebza, if you have what imparting shot.
I am grateful, Chair, for the opportunity to deal with these issues. Very clearly, the complications are not, yielding. We will do our best to deal with them, and we rely on this committee to help us navigate all of them, as you have very well done in the past. We are grateful for the opportunity today. Thank you indeed.
Thank you, Advocate Shame.
Apologies, I couldn't find my mute button for a moment. There's nothing to add from our side. Thank you to the members for listening to our presentation, and we look forward to hearing or receiving some indication on our question from the department next week. Thank you, Chair.
Thank you, Director General.
No, Chair, no further comments from our side. Thank you.
Thank you, colleagues, for your responses to the questions or comments by members. We are noting the two presentations. We'll further engage with the Department of Home Affairs, as the Director General has noted that they will be presenting their response in relation to the Constitutional Court judgment. We also note the matter raised by Honorable Pillay and Honorable Ross on the poor work of the administration of the Portfolio Committee on the matters that they've referred to. We'll deal with that separately. We note also the Advocate Bongani Bongo proposal that we need to request permission for the committee, because we're going to deal with issues that are focused towards the provincial and national election, but also assisting the Electoral Commission. We'll take note of that and interact with that. We've already indicated the issues that the Home Affairs will then brief the committee. Next week, we'll have a joint portfolio committee with the select committee to receive a detailed brief on the electoral amendment bill, since it's now been introduced to Parliament, and will take advantage to liaise with the issues that are before us as presented in the report. The committee will deliberate on the issues once also the Home Affairs has presented to the committee. The last point, which I think will engage with the Parliamentary Legal Service and also the legal service of the IEC and the Home Affairs in terms of the drafting of the program on how we must interact with these matters, with the time frame that has already been presented last week. Honorable Ross has noted that, and Honorable Khwase have noted that last week we presented with the turnaround time that we must work on to deal with these issues of the Electoral Matters Amendment Bill. So I think we'll engage administratively with the Parliamentary Legal Service and Home Affairs and IEC team. And next week, we'll attempt to present how we think we are going to engage on this process so that we're able to deal with that. That I think will involve the public comments and also the public comments and issuing of the advert for members of society to interact with this space. All the matters members have raised will interact with at the time we're going to deliberate and decisions to be taken on how we must move forward with the outcome of the Constitutional Court judgment, including the Electoral Amendment Matters Amendment Bill. Mr. Matonsi, is there any other matter that you want to note to the committee before we stand off or adjourn the meeting?
Yes, Chairperson, just quickly I know that the DG said no, they'll respond on the issue of the 15% for unrepresented political parties. What I've done already is to develop an advert. So I wanted that advert to be translated into other languages, bearing in mind that our last working day in Parliament closes on the 14th, which will be Thursday next week. So I might not have people to translate this advert into other official languages on time next week because people are taking this. So that is my only concern, Chairperson, because I wanted to ensure that no, the advert is on the advert is on the Parliament website before the 14th when Parliament closes. Yeah, so then the other issue, Chairperson, I'm not sure, maybe I should respond. You know, in terms of the link to the meeting, I don't know what happened, but I think Parliament had email issues even yesterday. The link was sent to all members, to the department, to the IEC, to everybody on the 6th. All the presentations that I received from legal service and from the IEC, I sent them yesterday. So I'm sure there was an issue, not I'm sure, there was an email yesterday that no, there were issues with the email that were going to be resolved by 12:30 yesterday during the day. So even Mr. Shibure, when he sent me this presentation, he called me, I did not get it. I have to give him my own personal email address to email me. And then I emailed to all members. And then I even confirmed with the researcher if he did receive his, because I was just worried that no, I might email and then I might not able to know whether people have received it. So it was not intentionally that other members did not receive it because everybody is on the group. I'm not selecting each member every time when I'm sending, I'm just clicking on a group to send to all members. So I just wanted to clarify that there was an issue of emails in Parliament. Thanks, Chairperson. That's all from my side.
Okay, noted. Let's not put the DG on the spot on how the department are going to respond because we're on record in the meeting. They will respond on the outcome of the Constitutional Court judgment. They've not highlighted specifics on the areas of their response. So I think we must close it on that manner, that they're going to respond on the Constitutional Court judgment. We'll have to deal with a matter, how you are raising it, Mr. Matons, in terms of advertising. And we'll have to advertise once the committee has received a presentation by Home Affairs. Let's see how we deal with it administratively with legal. But I think we must work within the the rules that guides the process on how adverts, once committee members fully appraise themselves with all the issues that are before them and guide on how we must deal with the issues. I think if we can wrap up like that, will assist the work of the committee. We want to thank the IEC commissioners, DG, honorable members for contributing to the presentation and responding to the Constitutional Court judgment and on how we need to move forward. We'll then discuss and deliberate once the DHA has responded as members have guided, and the Parliamentary Legal Service has cited that there are other areas that the DHA may need to interact with the committee. We'll then stand off these two items, and Mr. Maton, there's no any other item, then we can adjourn the meeting.
Yes, no, there's no other item, Chair.
Okay, thanks very much, honourable members and colleagues. Our meeting stand adjourned.
Thank you, Chairperson and members.
Thank you.